7 Fundamental rights. The fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of U.S., rightly described as the Magna Carta of India. Part 3 of the Constitution is rightly described as the Magna Carta of India. 1. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. The fundamental rights are guaranteed by the Constitution to all persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country, and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not of men. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are fundamental also in the sense that they are most essential for the all-round development, material, intellectual, moral and spiritual, of the individuals. Originally, the Constitution provided for 7 fundamental rights viz. 1. Right to equality, Articles 14-18. 2. Right to freedom, Articles 19-22. 3. Right against exploitation, Articles 23-24. 4. Right to freedom of religion, Articles 25-28. 5. Cultural and educational rights, Articles 29-30. 6. Right to property, Article 31. 7. Right to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act, 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of fundamental rights. The fundamental rights guaranteed by the Constitution are characterized by the following. 1. Some of them are available only to the citizens while others are available to all persons whether citizens, foreigners or legal persons like corporations or companies. 2. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. 3. All of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. 4. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. 5. They are justiciable, allowing persons to move the courts for their enforcement, if and when they are violated. 6. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the High Court. 7. They are not sacrosanct or permanent. The Parliament can curtail or repeal them but only by a constitutional amendment act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. The amenability of fundamental rights is explained in detail in Chapter 11.8. They can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression, i.e., external emergency, and not on the ground of armed rebellion, i.e., internal emergency. The suspension of fundamental rights during a national emergency is explained in detail in Chapter 16.9. Their scope of operation is limited by Article 31A, saving of laws providing for acquisition of estates, etc. Article 31B, validation of certain acts and regulations included in the 9th Schedule and Article 31C, saving of laws giving effect to certain directive principles. 10. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous services can be restricted or abrogated by the Parliament. Article 33. 11. Their application can be restricted while martial law is in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order. Article 34. It is different from the imposition of national emergency. 12. Most of them are directly enforceable, self-executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament and not by state legislatures so that uniformity throughout the country is maintained. Article 35. Definition of state. The term state has been used in different provisions concerning the fundamental rights. Hence, Article 12 has defined the term for the purposes of Part 3. According to it, the state includes the following: a government and Parliament of India, that is, executive and legislative organs of the Union government. B. Government and legislature of states, that is, executive and legislative organs of state government. C. All local authorities, that is, municipalities, panchayats, district boards, improvement trusts, etc. D. All other authorities, that is, statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. Thus, state has been defined in a wider sense so as to include all its agencies. It is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12, laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressively provides for the doctrine of judicial review. This power has been conferred on the Supreme Court, Article 32, and the High Courts, Article 226, that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following: a. Permanent laws enacted by the Parliament or the state legislatures. B. Temporary laws like ordinances issued by the President or the state governors. C. Statutory instruments in the nature of delegated legislation, executive legislation like order, bylaw, rule, regulation or notification. And D. Non-legislative sources of law, that is, custom or usage having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right and hence can be declared as void. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Kesavananda Bharati case 2, 1973, that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence can be declared as void. Table 7.1 Fundamental Rights at a glance. Category 1. Right to equality. Articles 14-18. Consists of a. Equality before law and equal protection of laws. Article 14. B. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. 2. Right to freedom. Articles 19. Table 7.2 Fundamental Rights. FR of foreigners. FR available only to citizens and not to foreigners. FR available to both citizens and foreigners except enemy, aliens. 1. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. 2. Equality of opportunity in matters of public employment. Article 16. 3. Protection of 6 rights regarding freedom of I. Speech and expression. 2. Assembly. 3. Association. 4. Movement. V. Residence and v. Profession. Article 19. 4. Protection of life and personal liberty. Article 21. 5. Right of minorities to 1. Equality before law and equal protection of laws. Article 14. 2. Protection conviction. Article 20. In for respect of offenses. 3. Protection of life and personal liberty. Article 21. 4. Right to elementary education. Article 21A5. Protection against arrest and establish educational. Article 30 and administer institutions detention in certain cases. Article 22. 6. Prohibition of traffic in human beings and forced labor. Article 23. 7. Prohibition of employment of children in factories etc. Article 24. 8. Freedom of conscience and free profession, practice and propagation of religion. Article 25. 9. Freedom to manage religious affairs. Article 26. 10. Freedom from payment of taxes for promotion of any religion. Article 27. 11. Freedom from attending religious instruction or worship in certain educational institutions. Article 28. Right to equality 1. Equality before law and equal protection of laws. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision confers rights on all persons whether citizens or foreigners. Moreover, the word person includes legal persons, viz., statutory corporations, companies, registered societies or any other type of legal person. The concept of equality before law is of British origin, while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes a. The absence of any special privileges in favor of any person. B. The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts. And c. No person, whether rich or poor, high or low, official or non-official, is above the law. The second concept, on the other hand, connotes a. The equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws. B. The similar application of the same laws to all persons who are similarly situated. And c. The like should be treated alike without any discrimination. Thus, the former is a negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. While Article 14 forbids class legislation, it permits reasonable classification of persons, objects and transactions by the law, but the classification should not be arbitrary, artificial or evasive. Rather, it should be based on an intelligible differential and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law, propounded by A.V. Dicey, the British jurist. His concept has the following three elements or aspects. I. Absence of arbitrary power, that is, no man can be punished except for a breach of law. 2. Equality before the law, that is, equal subjection of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. 3. The primacy of the rights of the individual, that is, the Constitution is the result of the rights of the individual as defined and enforced by the courts of law rather than the Constitution being the source of the individual rights. The first and the second elements are applicable to the Indian system and not the third one. In the Indian system, the Constitution is the source of the individual rights. The Supreme Court held that the rule of law is embodied in Article 14 as a basic feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Exceptions to equality. The rule of equality before law is not absolute and there are constitutional and other exceptions to it. These are mentioned below. 1. The President of India and the Governor of States enjoy the following immunities. Article 361. I. The President or the Governor is not answerable to any court the exercise and performance of the powers and duties of office. 2. No criminal proceedings shall be instituted or continued against the President or the Governor in any court during his term office. 3. No process for the arrest or imprisonment of the President or Governor shall be issued from any court during his term of office. 4. No civil proceedings against the President or the Governor be instituted during his term of office in any court in respect of act done by him in his personal capacity, whether before or he entered upon his office, until the expiration of 2 months and after notice has been delivered to him. 2. No person shall be liable to any civil or criminal proceedings in any court in respect of the publication in a newspaper, or by radio or television, of a substantially true report of any proceedings of either House of Parliament or either House of the Legislature of a state. Article 361a. 3. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof. Article 105. 4. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof. Article 194. 5. Article 31c is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that where Article 31c comes in, Article 14 goes out. 6. The foreign sovereigns, rulers, ambassadors and diplomats enjoy immunity from criminal and civil proceedings. 7. The UNO and its agencies enjoy the diplomatic immunity to prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex or place of birth. The two crucial words in this provision are discrimination and only. The word discrimination means to make an adverse distinction with regard to or to distinguish unfavorably from others. The use of the word only connotes that discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex, or place of birth with regard to a. Access to shops, public restaurants, hotels and places of public entertainment, or b. The use of wells, tanks, bathing ghats, road and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. This provision prohibits discrimination both by the state and private individuals. While the former provision prohibits discrimination only by the state, there are 4 exceptions to this general rule of non-discrimination. A. The state is permitted to make any special provision for women and children. For example, reservation of seats for women in local bodies or provision of free education for children. B. The state is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes for example, reservation of seats or fee concessions in public educational institutions. C. The state is empowered to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes regarding their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. D. The state is empowered to make any special provision for the advancement of any economically weaker sections of citizens. Further, the state is allowed to make a provision for the reservation of up to 10% of seats for such sections in admission to educational institutions including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This reservation of up to 10% would be in addition to the existing reservations. For this purpose, the economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Reservation for OBCs in educational institutions. The above exception, C, was added by the 93rd Amendment Act of 2005. In order to give effect to this provision, the Center enacted the Central Educational Institutions Reservation in Admission Act, 2006. Providing a quota of 27% for candidates belonging to the other backward classes, OBCs, in all central higher educational institutions including the Indian Institutes of Technology, IITs, and the Indian Institutes of Management, IIMs. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act, but the court directed the central government to exclude the creamy layer advanced sections among the OBCs while implementing the law. The children of the following different categories of people belong to creamy layer among OBCs and thus will not get the quota benefit. 1. Persons holding constitutional posts like President, Vice President, judges of SC and HCs, chairman and members of UPSC and SPSCs, CEC, CAG and so on. 2. Group A Class I and Group B Class II officers of the All India, Central and State Services, and employees holding equivalent posts in SUs, banks, insurance organizations, universities etc., and also in private employment. 3. Persons who are in the rank of colonel and above in the Army and equivalent posts in the Navy, the Air Force and the paramilitary forces. 4. Professionals like doctors, lawyers, engineers, artists, authors, consultants and so on. 5. Persons engaged in trade, business and industry. 6. People holding agricultural land above a certain limit and vacant land or buildings in urban areas. 7. Persons having gross annual income of more than 8 rupees lakh or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was 1 rupee lakh. It was subsequently revised to 2 rupees, 5 lakh in 2004, 4 rupees, 5 lakh in 2008, 6 rupees lakh in 2013 and 8 rupees lakh in 2017. Reservation for USs in educational institutions. The above exception, D, was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker sections, USES, in admission to educational institutions. The benefit of this reservation can be availed by the persons belonging to USES who are not covered under any of the existing schemes of reservations for SCs, STs and OBCs. The eligibility criteria laid down in this regard is as follows. 1. Persons whose family has gross annual income below 8 rupees lakh are to be identified as USES for the benefit of reservation. The income would include income from all sources, i.e., salary, agriculture, business, profession, etc., and it would be income for the financial year prior to the year of application. 2. Persons whose family owns or possesses any one of the following assets are to be excluded from being identified as USES, irrespective of the family income. A. 5 acres of agricultural land and above. B. Residential flat of 1,000 square ft and above. C. Residential plot of 100 square yards and above in notified municipalities. D. Residential plot of 200 square yards and above in areas other than the notified municipalities. 3. The property held by a family in different locations or different places cities would be clubbed while applying the land or property holding test to determine USES status. 4. Family for this purpose would include the person who seeks benefit of reservation, his/her parents and siblings below the age of 18 years as also his/her spouse and children below the age of 18 years.